The YSL RICO trial is not over yet. Court resumes on Monday with defendants Yak Gotti and Shannon Stillwell. I know a lot of the mainstream interest for this trial is going to be gone now, but a lot of people don't realize there's still 2 guys on the trial. The trial's not over yet. And there's only like 2 or 3 months left, so I'm still going to be covering it. And here's Doug Weinstein, Yak Gotti's lawyer. He basically begs everyone to keep supporting them. Even though Thug has gone home, they want the support.
So happy for Jeffrey that he is able to go home tonight, and I cannot wait for the day where Diamante gets a not guilty verdict across the board and he can go home. I was watching the streams on the various channels of Jeffrey doing his plea. While there were a lot of people that were supportive, I also saw a lot of people very down on Jeffrey Williams and very down on Brian Steele and Keith Adams for the plea happening today.
I can't believe that's real. Motherfucker got to go home. That's a W. Probation is sketchy. 15 years is a long time, but
I hope you guys keep watching the trial. I hope they keep streaming it. I hope enough people watch it so that they find a commercial reason to keep streaming it. Let's see what happens, but thank you all for all of your support. I hope you continue to watch the trial and support the 2 guys that remain in here that are fighting for their lives, just as we will continue fighting for them.
Okay, folks, I hope you guys are done criticizing Judge Whitaker. Does anybody think that this non-negotiated plea would have been feasible if we were still sitting in court with Chief Judge Glanville?
I literally said in the video, this trial would be in a dumpster fire if Glanville was still on it.
And what did Judge Whitaker do? She rationally considered the situation, she looked at everything, and she more or less went with the recommendation of Jeffrey Williams' attorneys and sentenced Jeffrey Williams, Young Thug, to probation. Does anybody think Chief Judge Glanville would have done that? Anybody?
If this situation happened to Glanville, he probably would have sentenced Thug like 10 to 15 years. Honestly, that's my guess. 60% of you aren't subscribed. Come on, hit the subscribe bell.
Good morning. We are refreshed and ready to go. Have no fear. Max and I continue to work for the release of our clients. Max and I met yesterday. We are doing preparation over the weekend for this coming Monday morning. Yes, trial is going to resume. No, my client is not pleading out. We have a lot of stuff going on. I want to say one other thing. I've noticed from my plea and Max's plea for folks to continue to watch this case, to pay attention to it, to shine a light on what is going on in Fulton County and within this particular trial. That request has been met with overwhelming support, and it chokes me up a little bit. I am so happy about it. So we're going to be working all weekend, taking a little time off, I'm sure, for our families, but
a lot of you probably didn't see the very end of the video where Thug walked free, the hour-long one I put up. At the very end, they come back in court and they start discussing Yak Gotti and Shannon Stillwell's pleas.
He's charged with count 57, which was participation in criminal street gang activity, which carries a sentence of 5 to 20 years. He was also charged with count 58, which is violation of the Georgia Controlled Substance Act. That is for the possession,
right, marijuana,
which carries a sentence of 1 to 10 years. As to count 59, I believe that's a possession of codeine with the intent to distribute, which is 5 to 30 years, and count 59, which is the possession of cocaine, which is
60 is possession of cocaine.
So 59 was the codeine, 60 is the possession of cocaine, which was 1 to 5 years. Possession of a firearm during the commission of a felony, which was count 61, which is 5 years to serve consecutive. Possession of a machine gun, which was count 62, which was 10 years to serve consecutive. And then he was charged with count 63, which is possession of a firearm by convicted felon pursuant to 1611-133. I know my math isn't the best, but that's life plus some years.
So Yak Gotti is facing life plus some years. And here's the plea they offered.
The state's recommendation, Your Honor, was for Mr. Kendrick to plead to count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, which was 20 to serve 15. Count 2, the murder reduced to voluntary manslaughter, 20 years to serve 15. And then to the gang count 57, also 20 years to serve 15, all to run concurrent, and the state was willing to null pros all the other counts in the indictment.
So 20 to serve 15 for those 3 charges, and I would imagine they were probably going to make him testify too. So that's where the deal breaker was as well, on top of being in prison for 15 years.
Kendrick and the attorneys associated with you, I want to make sure that y'all know that unlike what happened with Mr. Williams, If you plead non-negotiated to less than all of the charges, there is nothing that the court can do if the state chooses to go forward with some of those charges. So you could not do what Mr. Williams pled guilty or nolo to each of the charges that he was facing. You cannot say, well, I'd like to plead guilty to count 1 and I'd like to plead to the reduced charge on count 2, and then I'd like to just skip the rest of them, because the state can say, well, we're not skipping the rest of them, we're still going to try you for the rest of them. And the state can also say, well, we're not okay with letting you plead to voluntary manslaughter unless you abide by the terms of the agreement. We're going to go forward with the murder trial. So I know that Mr. Weinstein, you and Mr. Apt and everybody else who's been helping know that, but because things seem to have worked out sort of beneficially for some of these other people who have already pled, y'all might think, oh, well, gosh, can't we do something better than that? Given what you're facing, they hold a lot of the cards, and a lot of it is outside of the ability of this court to change, okay? All right.
We understand that, Your Honor. Thank you for advising us.
All right.
So they can't do the NOLO plea like Thug did.
Mr. Stillwell.
So now on to Shannon's situation here.
Your Honor, Mr. Stillwell is also looking at count 1, which the conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, which is 5 to 20 years. He is facing 2 counts of murder for count 2 and count 49, which each carries a sentence of life imprisonment. He's also charged with count 50 of this indictment, Your Honor, which is participation in criminal street gang activity, which carries a sentence of 5 to 20 years. He's also charged with count 51, participation in criminal street gang activity, also a sentence of 5 to 20 years. Count 52, possession of a firearm by a convicted felon, previously convicted under 1611-133, which is 15 years consecutive to any count in the indictment. 54, possession of a firearm during the commission of a felony, which is 5 years to serve consecutive. And count 64, which is another possession of a firearm by a convicted felon under 1611-133, which is also 15 years to serve consecutive. So Mr. Stillwell's looking at maximum of 2 life sentences plus
85 years.
Plus 85 years, Your Honor.
2 life sentences plus 85 years, because he has 2 murder charges on there and all the other shit. So you can imagine what their plea was for him, right? Let's see it.
The state's recommendation, and I'll just say globally, Your Honor, was 60 years to serve 40 years in prison, that we would have reduced both of the murders to voluntary manslaughter, Your Honor, and we had given his attorney the option to kind of craft how that 40 years would look, but that was the extent to our...
So 40 years in prison, reduce murder to voluntary manslaughter, but he has to serve 40 years in prison. 40 years. He wouldn't get out till he's like 70.
And Mr. Stillwell, kind of the same information to you. If the state does not want to reduce charges, you're not entitled to plead to reduce charges. They can say, you got to face these murder charges and we're going to make it a jury trial if you don't agree to what we're offering. Same thing, you can't say, well, I'd like those other charges dismissed if they're not willing to dismiss them in exchange for the negotiated sentence. So obviously each of you has the right to continue with the trial, have very capable attorneys representing you who clearly care very passionately about you all personally, as well as presenting your best case. But it's ultimately going to be up to the jury, and you cannot know what any jury is going to do. And they may say, I don't believe a single bit of this beyond a reasonable doubt. Y'all are both walking. They may say, you know what, I buy this, I don't buy that. I'm convicting you of 4 of the 5 or 4 of the 8 charges. You're still then going to face sentencing. They may convict you of everything. And if you are convicted of everything, Mr. Stillwell, you're facing 2 life sentences plus 85 years on top of that, as opposed to 40 years to serve. Parole is a possibility. And Mr. Kendrick, you are facing life plus, I think I added up 115 years, 20 to serve 15. So it's just something to think about. And I mean, it's already past 5 o'clock. So are y'all going to leave the offer open until you have withdrawn the offer before you even put it on the record to?
We communicated this to them last night, but they did not accept it. Then we will have withdrawn offer.
That's the best part of the whole day right there. The state has withdrawn their offer. Ooh. Oh no, you withdrawn it. They gave him an ultimatum the night before saying, if you don't do this by whatever last night, then we withdraw the offer. And now listen to what Doug Weinstein says.
All right, well, given that the state spent the entire day negotiating, Mr. Williams ultimately unsuccessfully, I don't know if either Mr. Weinstein or Mr. Sharp would have been able to negotiate with you during today.
They would have, no one would have any communication from Mr. Weinstein or Mr. And they rejected the offer.
Okay.
I did have communication with Mr. Abate today. I attempted to have communications with the DA last Tuesday morning, but she failed to show up for our meeting.
I think he's talking about Fonnie Willis. They had a place to meet, and I think it was like a coffee shop or something. He sat there for like 30 minutes to an hour, and she never showed up. Could you be any more unprofessional? I don't think you could. I mean, it's about someone's life. I just think that's baffling. But yeah, the trial's continuing. I'll be covering it because I think there is a chance they could get a not guilty verdict still. Max Sharp and Doug Weinstein are going to make this entertaining. They're amazing lawyers. They know what they're doing. They're not going to take no shit. So yeah, hit subscribe, join the membership. Love you guys. Peace out.